Welcome back to the deep dive. Today we're skipping the handshake, the negotiations, all the fine print. We are jumping straight to the end game.
The messy part.
The messy part. We are talking about remedies, specifically what happens when the deal falls apart and the standard formulas for damages, the expectation interest, just collide with the messy reality of construction sites or boat dealerships or international supply chains.
It's a fascinating area because, you learn in your first week of law school that the goal is to put the injured party in the position they would have been in.
Right. Simple math.
It sounds like simple math. But as we're about to see, that math looks very, very different depending on whether you're building a mansion, selling a speedboat, or shipping parts across the Atlantic.
Exactly. So we're going to dissect the specific rules for construction contracts, the sale of goods under the UCC, and international sales under the CISG. But first, give us the roadmap. What's our mission today?
Okay, so we have four distinct doctrinal buckets to fill. First, we need to clear up the add-ons. Specifically, can you get your attorney's fees and maybe interest paid?
Okay.
Second, we'll move to construction contracts and the famous, or maybe infamous, economic waste doctrine. Third, we tackle the lost volume seller under the UCC, which is a concept that trips up almost everyone.
Definitely.
And finally, we'll look at how the CISG handles incidental damages in international trade.
Let's start there, with the money that isn't strictly for the breach itself. So, say I sue you for breach of contract. After 2 years, I finally win. I've spent a fortune on lawyers. My gut says you should have to pay for that.
It's an intuitive feeling.
Can I make you pay my legal bill?
If you're in the United States, the short answer is generally no. This is the American rule.
Okay.
The default is that each party just bears their own costs.
Yeah.
So no matter if you win or lose, you pay your own lawyer. Unless.
There's always an unless.
Right, unless the contract expressly says otherwise, or there's a specific statute that allows for it.
That feels like a huge outlier, right? Compared to the rest of the world.
It absolutely is. The English rule, which applies in the UK, most of Europe, and Canada, works on a loser pays system.
And the logic there is to stop frivolous lawsuits.
Exactly. If you know you might have to pay the other guy's very expensive lawyers if you lose, you're going to think twice before you sue.
But the American defense of our rule is all about access to justice, I assume.
That's the argument. A loser pays system might discourage people from bringing good suits. A small business has a valid claim against a huge corporation, but they're terrified that losing on some technicality would bankrupt them.
I see. So the American rule encourages people to vindicate their rights without that kind of financial terror.
That's the idea.
So what happens when we go international? Say I'm a U.S. company, I sell to a French company, and our contract is governed by the CISG. Does that treaty override the American rule?
You would think so.
Yeah.
And a lot of lawyers have tried to make that argument. Article 74 of the CISG says you can recover foreseeable losses.
And in Europe, legal fees are a foreseeable loss.
They are. But U.S. courts have just shut this down. They've ruled that foreseeable losses under the CISG do not include attorney's fees.
So even if I'm trading internationally, if I end up in a U.S. court, I'm stuck with the American rule?
Unless you wrote a fee-shifting clause into your contract, yes. You're paying for your own lawyer.
Okay, that covers the lawyers. What about the time value of money? If you owe me $1 million and you don't pay me for 3 years while we fight in court, that $1 million isn't worth what it was. Can I get interest on that?
You can, but there's a catch. It all depends on whether the sum is liquidated or unliquidated.
Okay, break that down. What's the difference?
A liquidated sum is, well, it's fixed. Or it's simple math, like you failed to pay an invoice for $50,000. We all know the number. In that case, you can generally get prejudgment interest from the date the money was due.
And unliquidated.
That's where the amount of damage is totally up in the air until the jury gives a verdict. Think about defective work on a custom project. Was the damage $10,000, $100,000? No one knows.
So you can't get interest because the defendant couldn't have known how much to pay you.
That's the logic in many places, yes. They didn't know the number, so they couldn't cut you a check.
But that seems to incentivize dragging things out. You're holding the money interest-free.
It absolutely can have that effect, which is why some jurisdictions are changing, but the basic distinction is still a huge deal.
All right, let's move from the procedural costs to the physical world. Construction contracts.
The big leagues.
So the standard remedy is usually cost of performance. You build a bad wall, you pay me to tear it down and build it right. Simple. But there's this massive exception called economic waste.
Correct. The law wants to give you the thing you contracted for, but courts are also pragmatic. if the defect is pretty minor and fixing it would be just shockingly expensive compared to the benefit.
They shift gears.
They shift gears. Instead of the cost of performance, they'll award the diminution in value. So just the difference in the property's market value.
We have to talk about the classic case, Jacob and Young's Inc. v. Kent, the reading pipe case.
Of course.
Let's dig into that. What are the legally dispositive facts? What really matters for the court's decision?
The facts are almost comical. A builder constructed a wealthy man's mansion. The contract was incredibly specific, saying all wrought iron pipe had to be reading pipe.
A specific brand name?
A specific brand. But the builder, through an oversight, installed co-hose pipe in large parts of the house. And by the time the owner noticed, the house was done. The pipe was sealed up in the walls.
And was the co-hose pipe bad? Was it defective?
And that's the critical fact. No, the co-hose pipe was identical in quality, appearance, market value, everything. The only difference was the name stamped on the side of the metal.
But a breach is a breach, so the owner demands the builder fix it. But that would mean...
Tearing down the mansion.
Exactly. So what was the core legal issue the court had to decide?
The issue was, what's the right measure of damages? Is it the cost to replace the pipe, which basically means rebuilding the house? Or is it just the difference in the value of the home with the wrong pipe?
So what rule of law did the court apply here? State the full black letter rule, and if you can, break it down into its testable elements.
Sure. The court applied the doctrine of substantial performance and economic waste. The rule is, essentially, when a breach is trivial and innocent, and strict performance would cause economic waste, damages are limited to the difference in value.
Okay, and the elements.
You can break this down into 3 testable elements. First, you need substantial performance to have already been rendered. Second, the breach can't be willful or malicious. It has to be an innocent mistake. And third, the cost of completion must be grossly disproportionate to the actual benefit.
Thank you. So let's do the court's elemental analysis. How did the court apply that first element, substantial performance?
Well, Justice Cardozo looked at the big picture. The owner got a fully functional, high-quality mansion. The plumbing worked perfectly. So yes, the brand name was a technical breach, but in the context of the whole project, the builder had substantially performed. The defect was trivial.
Understood. Now, what about that third element, the proportionality of the cost?
This is the heart of the economic waste idea. To give the owner exactly what he asked for, that ridding pipe, the builder would have to destroy huge parts of the house. The cost would be astronomical. So the court weighed that massive cost against the benefit the owner would get.
And since the pipes were identical,
the benefit was 0. So the cost of performance was grossly disproportionate to the good to be attained.
So after walking through all that, what was the court's final conclusion?
The court refused to award the cost to replace the pipes. Damages were limited to the difference in value. And since the pipes were identical, the difference in the home's value was 0. The owner had to pay the rest of his bill.
It feels like common sense, but it also feels like it chips away at freedom of contract. If I want reading pipe, I should get reading pipe. So let's test this. Let's say I hire you to paint my house bright blue. I hate white. It's in the contract. You paint it white. A white house is arguably worth more. Can you use Jacob and Young's to avoid repainting it?
No, I can't. And this is a really important distinction. In Jacob and Young's, the pipe brand was incidental to the main purpose, which was a working house.
Right.
In your hypothetical, the color is the main purpose.
Right.
It's an aesthetic choice, and it's central to the whole deal.
So even if repainting it is technically wasteful?
Correct. If the breach defeats a central, personal, or aesthetic purpose, the court will award the cost of performance, so the cost to repaint it blue. The law isn't going to force you to live in a white house you hate just because it's more market efficient.
That's a vital distinction. Okay, let's pivot. Sale of goods under the UCC. We have to talk about the lost volume seller.
This one is tricky. It feels counterintuitive at first.
The general rule for seller damages is usually contract price minus the market price or the resale price. So if you sell it to someone else for the same amount, you haven't lost anything. But that's not always true.
Right. And it's not true for volume dealers, people with, basically unlimited supply of goods.
Let's analyze Neary v. Retail Marine. First, what are the key facts here?
So Mr. Neary contracts to buy a specific boat from Retail Marine, a boat dealer. The price was around $12,500. But then Neary gets sick and has to back out of the deal. He repudiates.
And what does the dealer do?
Retail Marine, being a dealer, just puts the boat back in stock. And very soon after, they sell that exact same boat to a new buyer for the exact same price.
Okay, so from the outside, it looks like no harm, no foul. They sold the boat for the same cash. So what's the core legal issue?
The issue was, did the dealer suffer any damages, even though they resold the boat for the same price? If you use that standard formula contract price minus resale price, the damages are zero.
But the dealer argued that wasn't right. What rule of law did the court apply here? Break it down for us.
The court applied the lost volume seller rule, which comes from UCC Section 2708. This rule lets a seller recover their lost profits if that standard formula isn't adequate.
And what are the elements to qualify?
There are three. First, the seller has to have the capacity to make an additional sale, a big supply. Second, they would have made that second sale anyway, even if the first buyer hadn't breached. And third, that additional sale would have been profitable.
Okay, thank you. So for the elemental analysis, how did the court apply those first two elements, capacity and causation?
This is the aha moment of the case. The court realized Retail Marine wasn't selling a one-of-a-kind item. They're a dealer. They can get as many boats as they want. Therefore, the sale to the new buyer was not a substitute for the sale to Neri.
Why not?
Because if Neri had bought his boat, Retail Marine would still have sold a second boat to that new customer. They would have made two sales.
Ah, I see. The breach didn't enable the second sale. The second sale was going to happen anyway.
Exactly. Because Neri breached, the dealer went from making two sales down to one. They lost the volume. They lost the profit on that first transaction.
So after analyzing all of that, what was the court's final conclusion?
The court concluded that Retail Marine was a lost volume seller. They awarded the dealer the profit they would have made on the Neri sale, about $2,500 plus some incidental damages for storing the boat. The resale was basically irrelevant to the lost profit calculation.
So the takeaway is if you break a contract with a big retailer who has a warehouse full of stuff, they can sue you for their profit margin, even if they sell the item to someone else the next day.
Precisely. But if you're buying a used car from your neighbor and he sells it to someone else for the same price after you back out, he can't sue you. He only had one car to sell. He is not a lost volume seller.
Got it. Let's move to our last bucket, buyer's remedies under international law, the CISG. In U.S. law, we talk about consequential versus incidental damages. Does the CISG do that?
Not explicitly, no. The CISG just talks about loss, which kind of covers both, but the analysis ends up looking very similar.
Let's analyze Delci Carrier Spavi Rotorex Core. What are the legally dispositive facts?
Delci, an Italian company, ordered air conditioning compressors from Rotorex, a U.S. company. Rotorex delivered them, but they were defective. They just didn't work. So Delci had to reject them and then scramble.
Scramble how?
They had to buy substitute compressors from someone else, but they also had all these extra costs. Shipping, storing the bad units, expediting the new orders to keep their own factory from shutting down.
So what was the core legal issue?
The issue was whether all those operational costs, the shipping, the storage, the expediting, are recoverable as damages under the CISG, or if Delci just gets the difference in the cost of the goods.
What rule of law did the court apply? Please state the rule and its elements.
The court applied CISG Article 74. It says damages for a breach are a sum equal to the loss, including lost profit. The key elements, or constraints, are that the damages must be consequences of the breach and must have been foreseeable when the contract was made.
Thank you. So for the court's elemental analysis, how did it apply that foreseeability element to these specific costs?
The court was very practical. It basically said, if you send someone broken parts, is it foreseeable they'll have to store them? Yes. Is it foreseeable they'll have to pay for expedited shipping to get replacements so their factory doesn't grind to a halt?
Of course.
Absolutely. The court found these weren't some weird speculative damages. They were direct out-of-pocket expenses to clean up the mess Rotorex made.
And so the court's final conclusion was?
The court awarded these costs in full. It showed that under the CISG, just like our UCC, if a buyer has to spend money to mitigate a breach, what we call incidental damages, those costs are fully recoverable.
Okay, so we've covered fees, economic waste, lost volume sellers, and CISG costs. We need to synthesize this. If someone's looking at a contract problem, how should they approach remedies?
You need a checklist, a diagnostic checklist. So if you're analyzing a remedies problem, here's the sequence.
Okay.
First, identify the contract type. Is it goods? You're in UCC or CISG land. Is it construction? You're in common law. Second, identify the breaching party. If the seller or builder breaches, you start with cost performance, but then you immediately check for the exception. Is there economic waste? If so, you drop down to diminution in value.
And if the buyer breaches?
If the buyer breaches, you start with basic expectation damages. But again, check the exception. Is the seller a lost volume seller? If they have an unlimited supply, you ignore the resale and award the lost profit.
Okay, what's next on the checklist?
Third, check for add-ons. Always look for incidental damages, shipping, storage, things like that. They're almost always recoverable. And fourth, check for limits. Subtract any costs the injured party avoided, and generally exclude attorney's fees, unless the contract says otherwise.
That is a really powerful framework. Use that checklist and you won't get lost.
And before we go, I want to leave you with one last thought.
Yeah.
In Jacob and Young's The Pipe case, the court really cared that the breach wasn't willful.
Right. It was an honest mistake. The court implied if he'd done it on purpose, the result might have been different.
Exactly. They might have made him tear down the house. But here's the tension. Contract law is supposed to be about economics, not morality. We don't award punitive damages. We even talk about efficient breach, the idea that you should break a contract if it's cheaper to pay damages.
But this case suggests the innocence of the breach matters.
It's a gatekeeper for the cheaper remedy. It implies that if you're a bad breacher, the law might just punish you with a higher cost.
It suggests intent matters more than we admit.
It does, so it raises the question, are we actually punishing the willful breacher? Is an efficient breach only efficient if you're, nice about it?
That is definitely something to chew on. Can you just buy your way out of a promise? Or does your conscience end up changing the price tag? Thank you for diving deep with us today.
Always a pleasure.
We will see you on the next Deep Dive.